That's it. And I will just turn it right over. Thank you, Virgil. So our theme is the harnessing the storm in legal education. And of course, the storms about which we are most concerned, quite rightly, are the ones in our own schools and in the communities in which our students practice. But there are some not inconsequential thunderheads external to that. And so it's the job of Bob and me today to describe some of those to you. Let me start by apologizing and saying there'll be no singing and no consultation on fearful moments and problems. We just have a huge amount of information to share with you. So please bear with us for our very non-clinical and non-creative presentation form. And we will try, and we invite you to stop us and ask questions, but we, especially when Bob gets to his incomprehensible charts, you gotta stop him and ask him. But we also plan to leave time at the end for some conversation about some of this stuff. So, yes, here are some of the sources of thunderheads outside of our schools. One of them is at the ABA. We're gonna talk about the ABA kind of generically today as the regulatory authority for law schools, the body which sends site teams to your schools and pokes around in your closets and writes a report and accredits you. We will refer to them as the ABA. For those of you who might be interested in following up on what they're doing, you'll find it in the section of Legal Education Council's website. You are all, perhaps unbeknownst to you, members of the ABA section of legal education by virtue of your school's joint membership in the ABA. And all of this information that we have for you today can be found if you poke around on that website. So, but we'll just call them the ABA for present purposes. Then we're going to cover such matters as, that are going on in the states as early bar exams and mandatory pro bono. And then Bob's going to spend a lot of time with you talking about plans afoot in the ABA and in state bars for increasing the mandatory experiential education. But my job is to start with us, the thing most important to us, which is our status within the academy. At present, there is an ABA accreditation rule that many of you may be familiar with that requires most clinicians have some form of security of position, either tenure or presumptively renewable long-term contracts. There are some outs on that, and it's an ill-enforced regulation. But the consequences of that regulation over the last 20 years is this, and this is data that Bob and David have acquired on behalf of all of our community that shows that about half of us have secure positions with respect. Maybe more, Bob?
About half.
About half.
These folks here, and then the ones at the bottom with the, so that
Right.
405C would be around 40% that have clinical or regular tenure, and then the ones down here that have at least a 5-year presumptive renewable contract.
So about half of us are secure in our institutions, and about half of us aren't.
And tomorrow?
Well, let me just say with respect to that result, that's been the consequence of a lot of very hard work and advocacy by clinicians in the ABA. And let me contrast it just for a moment so you'll have this in mind with the status of legal writing folks under which the ABA requires that they have sufficient security of position to ensure that they are competent. And that security of position has been held by sort of precedent within the ABA to be no more than a single year. To our knowledge, the ABA has never found a legal writing program to be deficient in terms of its competence at all, and many of the folks in legal writing programs have only 1-year at-will contracts. Okay, so stuff is going on at the ABA, and it is proposed to eliminate the requirement of tenure in the standards for everybody, and to replace it with one of two alternatives, which I invite you all to read these alternatives as lawyers, are actually identical. And they are. Alternative 1, you see it here. You have to be able to attract and retain a competent faculty, and you have to have sufficient security of position to ensure a competent faculty. That is the rule as we stand here today for legal writing people. So when this alternative is advertised as the security of position alternative, you need to see what security of position it is. It is such security of position as is necessary for a competent faculty. It's what legal writing folks have. It's at-will one-year contracts. Then we have alternative 2, which makes no mention of security of position and just says you have to have a competent faculty. So take a minute, think about these two things, and see that they are literally, in effect, identical. So the two alternatives that the ABA is now considering with respect to the status of faculty in the academy, both would require nothing more than at-will contracts for any faculty. We live in a real world. Keep in mind that this doesn't mean that tenure will be revoked across the legal academy nationally. It means that the people who have the status they have will continue to have it until they retire, but that new members of faculties can be hired on at-will contracts, be they doctrinal, clinical, or legal writing. So it will take a generation for the power relationships in a school to change, even if a school were to abandon all forms of security of position as of tomorrow. And I invite you to think about whether or not at your school it is likely that the tenure track will be abandoned for the doctrinal teachers, and whether it is likely, on the other hand, that the tenure track or long-term contract security will be abandoned for clinicians. It's a very worrying prospect, not just for all of us in the legal academy, our brothers and sisters on the doctrinal faculty, but especially for those of us who have fought so hard to gain some equality with the rest of the faculty, and who now are likely to be the first sacrificed as new hires are made. Okay, the big question with respect to security of position, other than your own long-term job prospects, is the extent to which you, as a member of the clinical faculty versus the doctrinal faculty, can participate in decisions about what goes on in your law school. So both of these new ABA, well, here's the current.
Right.
Here's the current thing. So as you can see, many people feel like the decisions on personnel are the most important decisions any law faculty makes, because those are decisions about who's going to have the vote at the next faculty meeting. We do badly on voting on personnel matters. As you can see, only 31% of us vote on all matters, or 30% of us vote on all matters. Many of us can vote on everything except personnel matters, but lots of us can't. I heard recently someone say that with respect to clinicians, that a question was asked, what are they doing here at the meeting, even though they sat quietly and voted on nothing, but were challenged by their mere presence at a faculty meeting. So it's very worrying about the extent to which clinicians will have governance rights under the new ABA regime, because both of the non-alternatives, require nothing more than a policy on meaningful participation. But without more, what a policy on meaningful participation would be and how the ABA would enforce it, I leave it to your imagination how low they could go. So it would require participation on the mission and direction, so you can help write your mission statement, and some participation on curriculum, but definitely not on personnel matters. Okay, so that's it for security of position for today. It's still a work in progress. I think it's fair to say that those of us who follow it are not overly optimistic that we'll be able to stop this change and maintain the gains that we've had over the last 20 years. We don't feel hopeless, but we feel worried. Yeah. Yeah, to ask a question, to be on the record.
Yeah, have a mic, right?
You need a mic. And the mic takes like a nanosecond to go on. Could you say who you are and where you're from?
Sure. David Kelsch from Detroit Mercy. So I've been trying to follow this, but one thing I'm curious about is if you can give us a sense of the timing and when this is going to happen.
Sure. So at present, it's kind of a complicated system. I'll describe it very briefly. The accrediting authority, the body that makes this decision, is the Council of Legal Education. It refers to a committee of it, which is not necessarily comprised of members of the council, called the Standards Review Committee, to make recommendations about changes in the standards. The changes that you've seen are recommendations of the Standards Review Committee, which were adopted for notice and comment by the council. So these have now gone from the council out to the public for notice and comment. One notice and comment hearing took place last month and nobody came. Oh, actually,
Gary Palm came.
Lots of you Midwesterners know Gary Palm, but he's the only one. But there's another hearing in February, which I think people are gearing up for, and I would invite you to think about whether you had some comments that you would either individually or collectively want to make. Then it goes back to the council for adoption in its March meeting, or adoption or not. And then it goes to the ABA, what we call the big ABA, the actual ABA itself, the House of Delegates, which can remand it, but cannot change it. So ultimately, the council has authority over these changes. So February is the next important date, the notice and comment. In Chicago, the notice and comment period. So those of you who are in Chicago should definitely go. I don't remember.
We'll get that on the listserv somewhere.
It's on that website?
Yeah, it's in February.
Yes. If you don't speak into a mic, your words won't be there for your biography.
Here's one right in front of you.
So I'm just confused about one thing.
And who are you?
I'm David Santa Croce. One thing you just said, the big ABA, as you call it, you said they can remand it, but they can't change it. But they can also just approve it.
They can acquiesce to it, right.
Right.
It's basically an
They
acquiescence.
can just say yes.
They can say no problem.
And that happens in August.
Right.
And was there any discussion of is this going to, because there's a couple of things coming up. The experiential education requirement that you're going to get, I think you're going to get to.
I hope so. You don't slow us down too much.
Well, will that be immediate?
Yes, but the way this usually happens is schools don't get around to it until their site visit. So even though theoretically it would go into effect immediately, I think most schools would not get around to worrying about it. But you have to keep in mind, this doesn't mandate anything other. The only mandate possibly showing up for the first time might be more participation by some clinical faculty in governance matters relating to curriculum and mission of the school. Other than that, the school can do or not do anything they want. So we ready?
Okay, a few other things that are going on out there. You probably have heard that New York, as of 2015, is going to require that every applicant for the bar have completed 50 hours of pro bono. Since so many of you send your students to the great Empire State for employment, this is something that you've got to have on your radar screen and figure out what to do with. It's also a movement that's growing among the states. These are the kinds of activities that qualify for the New York pro bono requirement. So your clinical programs do fulfill a requirement, and it's for sure that every one of your students in every one of your clinics will have 50 hours of pro bono, sufficient for the New York rule by virtue of having.
Whether it's true at your school, Deborah Epstein at Georgetown said that upon students hearing about this, they were showing some renewed and increased interest in doing a clinic to make sure they got their hours and got it in a way that didn't require them to do something more. So, but it could come to your state.
And it's in your state as long as you're sending folks to New York. Yes? Yes, so we're going to get to that. So the National Conference of Chief Justices just this summer endorsed the notion of of having every state consider this mandatory pro bono. So you need to think about the extent to which the mandatory pro bono, which is standing on its own a thing which you might, well, think was a very good idea, but it also will have some potential impact on your clinical program, just as Bob mentioned. And so it's part of the picture of what you need to be thinking about as you negotiate the future in each of your individual institutions.
Yeah, I think it's pretty clear that California will adopt 50 hours. It's out there. They proposed it. They're now just in the... They're now tweaking the rule. And New Jersey looked like they were on the verge of doing it and may still, because this summer they too had a public comment period on it. And but whether that happens there or they sit on it, it's hard to know. So.
Ohio too is...
Ohio's, lots of states are mumbling about it, so.
Yeah. Do we have Ohio people here? There's so much interesting stuff. We're going to have to talk to you. There's
You'll
like
see
really
later. We'll talk about some
going
things
on
in Ohio.
Okay, early bar admission. What we're really thinking about is early bar exam. This is something that's really interesting, and it would be great if you sat down and sort of brainstormed about the upsides and the downsides of early bar exams. Now, of course, there's some sort of loose talk about a two-year law school, loose talk, for example, from our president. The notion being that you don't learn that much in the third year of law school, which, of course, if you do nothing but take more law school courses, there's maybe something to it. But as we know all too well, after 2 years of law school, a person is far from competent to practice law. It's a chilling thought, actually. So the notion of taking the bar exam after 3 semesters or 4 semesters or even 5 semesters, leaving the rest of law school for experiential learning is one that I think ought to intrigue all of us. You know, in medical education, there's a staged procedure for licensing, and medical students get rid of the science piece of their licensing exam early and go on to the clinical piece. This has some of those qualities and may well be something that we might not only want to think positively about, but actually organize around. You could get rid of the damn bar exam after 3 semesters in law school and have students actually learning their craft in the last 3 semesters of law school. Perhaps we would have achieved quite a lot. So
Yeah, so if I could cut in, so for example, in Arizona, where they passed this and it's now in effect, what's going to happen in Arizona this fall is that a group of students who want to take the early bar will, for leading up to the bar in February, just take generally 1 course, and it smells a little bit like a bar prep course, but of course they're not allowed to do that. And then after they take the bar exam in February, they come back for the next 8 to 9 weeks of nothing but experiential courses, either mini clinics or simulated courses or externships. So they've used this, I hate to call it dead time, but this post-bar exam time when students, quite frankly, wouldn't want to go back and sit in class anyway, is a way to at least ensure in a brief period of time that they're all getting a little more hands-on experience.
right, so without mandating more experiential learning, the Arizona Supreme Court has managed to put that into effect because of the choices that law schools and law students are making in Arizona. So that's interesting stuff.
So you're done.
So I'm done. Okay.
We'll have lots of time for more questions and chatter about this, but let me just get to some other parts and then we'll see where we are. So I want to talk about the curricular changes that might be on the horizon, both as a result of standards that the ABA has proposed already to change, that as we heard will be further heard in comment period in February and possibly adopted and go into effect this summer, and then some fairly significant developments at the state level. So first, a fairly, I don't say minor, but not terribly dramatic change for field placements or externships. At present, if the externship is 4 more credits, you have to have regular contact in some way and some student reflection that's contemporaneous. This is going to go down to even 3-credit externships. A little troubling thing we're still working on is that it would allow some of the contact with the student and the oversight of the student during the semester potentially be done by an administrator and not a faculty member back at the school. And I think many of us are worried about that slippery slope to externships ending up in the Career Services Office, and we're troubled that this insertion of this phrase may in fact open it up to that. I think the ABA would argue, no, this just means maybe an administrator could go actually on a site visit, but I don't think it reads that narrowly. So there is some concern about whether we've gone down another path. This is an issue that's going to explode. So The issue of whether students can get credit for externships where they also get paid, it went through the standards review by one vote to keep the current prohibition on for-pay externships. Went through the council without any discussion, but then there's a lot of continuing sort of talk about it, and the Standards Review Committee recently announced they're going to revisit this. This won't happen immediately, but maybe in the next couple meetings they're going to go after this again. I know from the last Externship 6 conference there was sort of a session on that, and there was overwhelming support to keep it the way it is. But this is, as you can imagine, with the debt students are facing, somewhat under attack. The real worry is that every student who does a summer job will come in and want to get credit for it at some point later. And it's a big issue in California, as we'll see in a minute, because they're feeling a lot of heat to potentially allow it. You'll hear a lot of chatter about, oh, the ABA is now requiring learning outcomes, right? They did what best practices talked about. But you need to look closely at that, right? And like a lot of things the ABA does, they figure they just encourage something and then get out of the way. So it is the case that in theory there will be learning outcomes. I think it's possible that could be as simple as learn the elements of a contract, learn things like that. And
Pass the bar.
Yeah, pass the bar. They have to have competency in other professional skills. They refuse to specify what those competencies were. So I think this basically just means at some schools that read this in good faith, it could be a way to sort of bully pulpit the school into coming up with some true efforts to define what students should learn and measure it, but I don't think the ABA will be policing it. Similarly on assessment, right? People said, oh, wow, we're now going to get both formative and summative assessment of these outcomes. And if you look, it just means somewhere in your school, some class, some course, somewhere, someone has to be doing formative assessment and somewhere summative. And so since we do lots of formative assessment in clinical courses and legal writing courses, I don't think it's going to do much, although it's not, again, to say that at your school you couldn't see this and try to encourage the school to do more. But this is just sort of the frustration many of us have working with the ABA, is that you think something sounds good and then you see that there's really not much behind it. And as we talked about those outcomes earlier, you're not supposed to just set the outcomes, but you're supposed to evaluate it. But again, I don't think there's any real hard new ways to do that, because we've been doing grades for years, and this is just examples of it. And so one could argue that as long as you're grading a student in a course where you said the goal was for them to learn administrative law, you have set an outcome and you have measured the outcome. I think in defense of the ABA, what they would say is this is all new, and we want to give schools a chance to sort of figure it out, and we can come back in 3-5 years and perhaps impose a little more. But I don't, I went to a conference and somebody there was just bubbling with excitement about what the ABA was doing on outcome measures and assessment. I don't want you to leave here bubbling. There's not much to bubble about. So, skills. Let's see what's going on here, right? So as you know, at present, this is the bottom, even though it says that students shall have substantial instruction in professional skills, the ABA has interpreted that as 1 credit. Somewhat, they had
Out
changed.
of how many, Bob?
Huh?
Out of how many?
At 87. When the ABA had drafted this about 6 months ago, and Standards Review had done their 2nd or 3rd round on it, they changed it to a course. When we suggested that a course could still be 1 credit, they said, okay, 3 credits. Then California came along, as you'll see in a minute, with 15 credits, and the ABA felt sort of shamed. And so someone, just out of the blue at a meeting, said, well, what if we just do 6? And literally it happens like that. And so now it's 6, which I guess is 2 courses. So the big change here is that if your school now says a student has to have a skills course, it will have to say skills courses amounting to at least 6 credits. For some students, this will make a difference. We saw at our school, we ranked our students about the number of skills, and some had, one student, I don't even know how they did, had 39 credits of skills down to 1. So at least the bottom will be pulled up a little bit here. And theoretically, this goes into effect immediately, though again, it would be in effect for the fall, but I don't think it's going to happen that quickly at most schools. And this is another part of it, right? What does it require, right? This is trying to define what a professional skill is. They're now calling it something different. They're now calling it, 6 hours in experiential courses. And they've tried to define what goes on in it. This is, a good effort to make sure that, not everybody raises their hand and says we have a skill course. And it's a sort of, the kinds of things that we would hope, right? This is a bizarre kind of effort on their part to say that these don't have to be assessed by the instructor, so you'll see what can happen is you can tell students to go off in the corner and do a skill amongst themselves, and you've done it, right? That there's no requirement for the instructor to be in on it and to give the feedback they need and even necessarily, the student to sort of learn from it. So let's talk about yeah, sure.
I'm sorry, it's me again. Did you say that passed?
It passed out of committee, it passed out of council, it's up for comment, and then it'll be this summer.
That's the August thing again.
Yeah.
Okay.
I don't think this is changing much. I mean, there's just not much groundswell to do anything about this, and they're content with the 6. They seem to think
One thing that's interesting is that the standards review had recommended that the 6 credits be after the first year, and in a very random way, the council, when it got it, took that after the first year provision out. So it would have been much better if it had been left the way it had been.
Okay, California. In some respects, I teach environmental law, and people like to say the states are the engines of invention, and I think we may be about to enter that era in legal education, because California, as we just saw, New York way out front on this pro bono requirement, and now California, as you've heard about. So this is the California requirement that's gotten quite a bit of press, right? And that is that as a condition of sitting for the bar, students have to have 15 academic units. This is the buzzword, practice-based experiential training. We worked hard to get that word practice-based in there because we were worried that people might say, oh, upper class legal research and writing class by a doctrinal seminar or doctrinal professor works. So I think we've done that pretty well on that. This is the sort of unknown thing, right? They're worried, and perhaps rightfully so, that a student may attend a school somewhere and either not think about it or not have an opportunity to get the 15 credits. They still want to take the bar. Shouldn't they have some other way to get the equivalent? And so they add this equivalency here, right? And that is outside of the school, you could go and do an externship or clerkship or apprenticeship that was quote unquote bar approved and have the same eligibility. And this is what we're not so sure about, right? See at the bottom, we're just not so sure what that means, right? Again, will every student come in after their summer job and turn in a form and said, look, I worked 40 hours for 10 weeks. I want my 8-10 credits of experiential learning out of the way. The good news is that we did have some success in fighting off first-year legal research and writing, right? We wanted it just to be the last 2 years. They wouldn't do that. It could be other first-year courses on the idea that we should be encouraging. This is a good thing, right? Schools to experiment in the first year with more practice-based experiential courses. So at least in this respect, I think it's reasonably good. And where this is that it was drafted, went out for comment, now goes to a committee that's supposed to actually put it into more regulatory language. Then it'll be sent out again, probably for comment, and then ultimately goes to the California Supreme Court, which would have to vote by majority to adopt it. I think that's the only unknown. I mean, I think it's pretty clear that the California bar that's drafting this will get it out probably in a form that's pretty similar, and we'll just have to hope at the end of the day that the California Supreme Court's there to do it. Yes?
Does the rules specify what the equivalent hours for 15 units are?
Not yet. That'll be part of the rulemaking.
Apropos of your introduction, you get rid of all the clinical professors. Who's going to do all this?
Yeah.
Right, so that's...
Any thought about that?
Well, that's what, this is what we're going to have, right? We're going to have this. It may be that they don't have to hire us and they don't have to give us security of position, but if they have to deliver this product, they're going to still need us.
Right, so this is the tension, right? That the bar wants more of these experiential courses in law school, and the ABA wants less regulation of the status of the very people that we're going to be doing it. You know what I mean? It's a really... it's quite a thing. Yeah. So one of the things that we'll see. one of the things we really want to work about here, Ohio had a task force that had a similar provision, and they had something like law school, I don't know if it was law school approved or law school, something that put the law school in the business of making sure that these out of law school experiences were legitimate, right? And so I think, just sort of speculating about what Claudia might do in the next round is work hard on this phrase, right, to make sure that what it takes to have a clerkship with a judge count if it's not part of a law school course, mirror the same things that we would expect if it were a law school course. But we'll see. Stay tuned. So, as you may know, CLIA, following up on the 15 credits of California, petitioned the ABA to do the same. And as you could tell, because they're still stuck on 6, they rejected that, but I think credit could be given to Kate Cruz and the CLIA officialdom, that I think at least by asking for 15, they gave us 6, because otherwise they would have been stuck still on 1 course. But we also...
Not only that, but there were a number of people who said, come back next year and we'll give you 15.
Yeah.
So.
We also, in that petition, asked for a mandatory clinical experience. They just not even gone on that at least part of those credits would have to be in a law clinic or externship. So some interesting stuff in Ohio that's a little hard to read, right? So Ohio had a task force and made some tremendous recommendations, both in terms of the kinds of courses people should have in law school and their ability to take the bar. And the Chief Justice announced when she sort of accepted it last September that she was going to appoint a task force of deans. And the interesting thing was not to tell us if they liked it or not, but to tell us how it could be incorporated. To me, it was a charge to them to go show how you would make this work. I don't think that's what's happened, at least not yet, right? There's no apparent effort so far, though I think that probably there will be soon. And the interesting thing is, from some data you'll see by me in a minute, just looking at these Ohio schools, 8 of the 9 high school law schools, all of them but Ohio State, tomorrow could mandate a clinical experience for every student and not have to change a single course, not hire another new faculty member, not add any new slots in clinic, anything. I mean, it'd be so painless, it'd be nothing. And Ohio State is almost there. I mean, Ohio State maybe even be there if their enrollment's down this year. And so it's an interesting thing to me to see why there's all this resistance to something that, quite frankly, is sitting around in your school, and it's just a matter of you deciding that that's what a student shall have as opposed to could have.
Yeah, it's important to note that the resistance to this stuff comes from law school deans. Not every law school dean, not every law school dean in Ohio, not every law school dean in California, but they're just worried about being told what to do and sort of having to fit things into the right pegs. So our job is to talk to our deans. You guys in Ohio really got some work to do. You got to organize Ohio and get all of those deans to back down, because this is going to happen in Ohio as soon as those deans just...
If the deans get out of the way, it will happen, right? So what about, again, trying to comply with Virgil's mandate to stick with the theme. If we've given you a pretty interesting storm, some of which you want to get out of and some of which you want to figure out how to, trim your sail to catch, how can you harness that? And so I want to give you some, at least one possibility is think about what's already going on in your schools and sort of a data approach, right? So first, let's start with this. One of the things that motivated us to sort of gear up some things for CLIA in California was just the recognition that we are just such an outlier among professional schools in what we require of our graduates as a condition of graduation, right? And so this is just comparing across other professions, their clinical or experiential or hands-on practice-based requirements, and it's laughable. It's really laughable. And the interesting thing is most of these professions, as you know, also have some mandatory apprenticeship, internship, residency, or something they have to do for another year or two before they get a license. And so this is was a pretty powerful sort of thing to compel us to sort of move forward on this. And the common claim, and this is what I want to talk to you a little bit about today, is we can't, right? It just costs too much, right? It's fine and good for you, Claudia, to be asking for all this stuff, 15 credits, mandatory clinic or externship. It's just too expensive. And for a while, that was Alda's, the law dean's rap, right? But other people make this rap, right? Even our own peers believe, you know what, if we did this, it would cost students more, right? With the rightful concern now about anything we do driving up tuition for students that are deeply in debt, right? So these two very thoughtful members of the Ohio Task Force disagreed with the majority report that said there should be mandatory clinical experience because they said we're worried about the cost of it, right? So I want to give you some insight into, does this really cost students? Okay, not does it cost to teach someone more in an 8-credit course than a 8-student course than a 50-student course. That's sort of self-evident. But the real question, at least for these people, was, is the result of requiring more of these courses going to be that poor students have to bear the burden of higher tuition to pay for these lower enrollment courses? So let's look around and see, right? We have some real-world examples already, right? We have Kuehn, has for years been providing tremendously high-quality clinical education, mandating it for all students at really, really, really very low tuition rates. No indication there it's costing them more to do this. Same thing at the University of District of Columbia. And the most recent real-world experiment, of course, at Washington Lee, where they took a very traditional curriculum, mandated a third-year 20-credit experiential requirement, plus clinic or law externship for every student. And when they did a review after 2 years, didn't cost them any more. In fact, cost them less. Yes?
Sorry, I don't have a mic, but
Who are you?
my name is Linus Chan. I'm currently at DePaul, and I'll be going to University of Minnesota at the end of the year. My question on these is how often are these places you relying on adjuncts? Because that's what my experience has been, that adjuncts are so much cheaper, and they allow an ability for a school to say that they're giving clinics, though they're very different qualitative.
Yeah, so here's an interesting thing about these. These people have tenure, right? CUNY has tenure for its clinical faculty. UDC has tenure for its clinical faculty. It's a small faculty, I'll tell you that. Washington Lee has sort of a mix. They will tell you that how this happened, how they could do this, was that they did bring in adjuncts. They have these you'll hear about this tomorrow from James Moliterno, these really interesting third-year practicum courses where they bring in someone who's been doing mergers and acquisitions, and they bring them in a 2 or 3 credit, very intensive, hands-on, skill-based course to learn how to do that kind of work. So at some respects, yes, I think if you're moving from not having it to having it, at some level you'll be using more adjuncts, but I think in a good way, right? I mean, we don't know if you're going to be replacing full-time faculty, but in a good way if the result is more really great upper-level hands-on courses by experienced lawyers that put students really in an opportunity to learn the skills. But there's no doubt that, again, this all ties into this issue of status, doesn't it, right?
Also, externships count, and they...
Right. So I thought I'd do
have
something,
no
right?
teacher.
So after hearing this narrative, constantly, oh, it's too expensive, and then not just too expensive, but it costs students too much, I wanted to see if that was true, okay? So I decided to pull some data together, right? I pulled a bunch of data off the law school admissions official guide on your school, my school, size of your class, courses you offer, how much are you charging. I looked at ranking because I wanted to see if ranking had an effect. We got our C-cell data and then some cost of living. And so here's what I wanted to find out. I wanted to find out at schools that are offering superior or more clinical opportunities, do we also see their tuitions higher? In other words, is there a relationship between the more you're offering students in terms of clinical education and tuition, or not? Or is it possible that schools have figured out a way to create all these opportunities for students and aren't charging any more than the schools that aren't doing it at all? Okay, so that's the issue I was trying to test with this data, right? And this is where, as I said, I got a lot out of it. If you've ever seen this on your school, but your school, David's on the ABA committee that drafts the annual questionnaire. They pull this data off the annual questionnaire. These are enrollment numbers. Here's your tuition number. Here's your JD class size number. And so I took a lot of this. I got these big spreadsheets with lots of data, and so I then ran some regressions to figure out, okay, what's going on. First I wanted to worry about is there's some, for lack of a better term, sort of noise out there, some things that drive tuition that I needed to control. So I controlled public-private, because you can see private schools on average charge a great deal more, 19,000 more than public schools. I looked at rank, and you can see that rank matters. This by each one place in rank that you go down, theoretically you have to charge $100 less, right? So if your school's 10 below another, to at least in the view of the schools, the market is requiring you to charge less, okay? And non-ranked schools I couldn't do a continuum on, but you can see non-ranked schools By that I mean the ones that are below 144 in US News charge on average 14,000 less than the others. I looked at cost of living because I was early on sort of getting some noise. Cost of living matters, not a whole lot, but makes sense, right? You're going to pay more in New York than you are in North Dakota. But I can run it with or without that variable, and the data is pretty much, at least the ultimate thing's the same. Just for you geeks, this is telling me this is capturing a lot. 65% of the difference in tuition is based on these factors right here, right? And if I add in cost of living, I can get to 75%. So this is a pretty good, this is a pretty good picture of the world here, right? And let's say what we're doing, right? So the first thing I said, I'm going to test the California issue, right? Is it going to cost schools more, or is it costing schools more to provide more experiential courses? By experiential courses, we mean law clinic courses plus externship courses plus simulation courses, right? So when I add all those courses together at a school, and I control it for the number of students, and I run it against tuition, right? So this is the data thing, right? I would get a ratio, right? And what you find is, the answer is no. The answer is, at least from a statistically significant point of view, there's no relationship between providing more experiential courses and tuition, right? So this tells you, at most, if there was, it'd be very small. And that p-values, for if we don't get a p-value at least about 0.1 or something, this is just garbage. I mean, this just means that you can't show any relationship at all. So I think it's fair to say, at least from a statistical point of view, people that claim that, adopting the California requirement will drive up tuition, it's just garbage. At least it's garbage in terms of the data. Clearly doesn't show that, because schools that already are providing lots of experiential courses are not on average charging more than the schools down here that aren't doing it at all, right? So the common response to that is sort of your response. So of course, because they're dealing with adjuncts, right? So I said, okay, let's look at a different thing. Let's just look at whether law clinics plus externships, clinical legal education, right, is costing more, right? Schools that provide that, not just and simulations, okay? So we go to the next thing. What about, schools that have gotten in on the thing about mandating clinical experiences? Are they charging more, right? And so I looked, based on Karen Tokar's work, that's now gone up to 21, at the 19 schools that are already mandating this. And I said, is there something about these 19 schools? Are they charging more in tuition than the rest of the schools that don't do this, right? Did they have to get there by charging their students more? And the answer is no, right? Again, they charge less. But again, the p-value is just so outrageous, I can't say anything about it. But basically say there's just no relation. This is the chart that drives some people nuts, but if you grew up in biostatistics, it doesn't drive you nuts. Let me tell you what you're seeing.
Thank you.
Because this is this is a good thing. This shows you.
Turn the page.
So this shows you a good thing. So this is a scatter plot of the data on the mandatory schools, right? So some of these little plots are the 19 schools, and the other plots are the rest of the world. Some of the plots are public schools, and some of the plots are private schools. So this is 200 schools, and where their tuition is, ranked by tuition along here. This is tuition, and this is rank, right? And this is just fitting a line, right? It just looked at this and tried to fit a line. And let me just show you what this tells you that you already have told, right? First of all, here's the difference between public and private, right? You can see that really dramatically here, that there's a huge difference. And the fact that the line slopes down as ranking goes down is the other, shows you the influence of rank, right? So regardless of whether you understand anything else, this shows you what I just showed you with a number you might not have known, right? That rank matters and public-private matters. And even when I control for those, this shows you there's no real relationship, right? The nearness of those two lines is the thing I talked about a minute ago that shows there's just really not a statistically significant difference, right? So this is just, I run these on all the things I do because sometimes you get a number and you want to make some sense of it, and this makes sense, right? Because this at least makes sense to me, Virgil. I apologize otherwise.
Keep asking. If you have more questions, if you still don't understand it.
You'll see another one in a minute.
It's been 25 years since I had a course on this. Maybe I need to take
Yeah.
Did you run, so back up, I want to call sleight of hand. No, go forward one. So I think we can all, even those of us in the room who teach only externships, all of us can agree that we wouldn't want to see law clinics go away
I'm going to get there. Hold your thought. I know what you're going. You're going, okay, you've put in cheap externships with expensive clinics. That's right. Okay, I know that, and I heard that, and I heard that from other people. I heard a lot of this stuff, and so I used to come in every day and try to see what was going on. So this means if you mandate, there's no evidence that if you are a school or the schools that are adopting mandatory clinical education are charging students anymore for that. I mean, the flip side of this is the outrageous part, is that students are paying just as much and not getting it, right? So what about if you just guarantee it, right? Which a lot of other schools have done. Same thing again, you know, I ran that, and again, you know, I mean, some tiny amount, but it's really not, this is such a number that just tells you nothing. So it tells you the same thing. The schools that are guaranteeing this also aren't charging anymore, and here you go. Now you know what that means, Virgil. And again, what that tells you is these lines are so close to, because they're indistinguishable on this scale, it shows you there's really no difference between the schools that are guaranteeing it and the schools that aren't in terms of what they charge in tuition, okay? So then I decided to look at whether the schools that have done this, nonetheless, have had to sort of catch up, right? After they adopted it, right? After they adopted a mandatory clinical education requirement, did they start charging more because they had to? The answer, again, is not really, right? I don't have a really large data set on this because a lot of these schools have done this recently, but not at all. If anything, you know, their rate of increase since then to today has been less than the national average, so there's just no evidence that, you know, yeah, today they look fine, but they caught up in some way because they had to start paying more to provide either a law clinic or an externship experience. So then I tried to ask this question: who could do this today? Who has enough capacity today to mandate a clinical experience without changing what you do, right? I just sort of gave you a hint, right, that 8 of the 9 or 9 of the 10 law schools in Ohio could do it. So I looked at a couple things. Again, I pulled off the data. I got the number of students, right, the number of slots at your school in your law clinics, the number of students actually placed in externships, not the infinite number, how many you could, but how many did you actually place. And then I created what I call a variable clinical experience capacity, right? So I looked at how many positions are available in your clinical courses, these two, your clinical courses, law clinic courses, and your field placement, and then I divided that by your enrollment, right? So this gives me a ratio, right? It tells me that if I get a number 2.0, that means you have twice as many slots available in law clinics or externships as you do first-year students coming into your school, right? And so anything above 1, right? Any school has a ratio above 1, means that right now, at least based on this data from last year, there are enough slots in your school for at least your entering class, that's the only data they give me is the 1L class, that tomorrow you could mandate it and you wouldn't have to change anything. So if you have an enrollment of 150 students and the number I get is, and I find you have 156 courses in those particular clinics or externship or slots, then the number would be above 1 and you could mandate it tomorrow and you don't have to change anything, right? So let's see what we found. 80%. Yeah.
Neister, I thought you were going to distinguish between externships and clinics because
I'll get there.
Oh, because you keep adding them together.
I'll
it's
get
just
there.
to heighten the tension.
I told you to get there. I'll get there.
I thought you were there.
It's creating creative tension in the audience. It's just, please. So here's where we are, right? This is a pretty interesting thing that 80% of the schools today could adopt this required clinical requirement that only 21 schools have done thus far without having to create any new slots in any existing course, okay? I don't have to add anybody, faculty, add any courses or whatever, right? That's because they have this ratio is more than 1, okay? And these other schools up here are pretty close. Some schools have it quite a ways to go, okay? This is true in my school. You know, my school tomorrow or today, whenever, could say from now on, every student shall have it. All we'd have to do is, you know, some students would no longer be able to take a second or third clinic. I mean, that would be one consequence, right? And surely lots of students who aren't doing it would have to do it, but it wouldn't necessarily change what we're teaching. Over time, it might change our mix because students may complain and want something different in the mix. But this is a pretty significant thing, and I've got plenty of data on your school, or you can pull it yourself. But this is, you know, why even if the ABA were to adopt this mandate, 80% of schools would have just shrugged their shoulders and said, okay, well, I guess we have to do it. And the others, I think, are close enough that it doesn't require a whole lot because, as has been pointed out many times, you can add externships, right? Or if you're really worried about the cost, you could add adjuncts, okay? So this is, I think, a fairly significant thing to think about, right? That we're here, we're there. It's just the will of the faculty to mandate this and what that means, at least at surely overwhelmingly number of the schools, right? Okay, so what about the cost issue though, right? So what about, is it possible that these schools are charging more, right? Now we know that 80% of schools that can do it. Is there some difference between these 160 schools and these schools up here, right? Are these charging more and that's why they can offer or are offering more, okay? So I compared this, right? And this is just for you to see. The top part is how I did it, and again, always looking for ratios more than one. And so I have this scale, and I can show every school, right? And how many courses are you providing per or slots per student from, like, I think one school has 7 point something down to like, 0.3 or something, and run the regression against that against tuition and see if there's a relationship. And again, the answer like before is no. Again, no. The 180 schools that today offer their students enough clinical course slots to put them all in a seat are not charging more on average in tuition than the schools that are not providing that opportunity. Again, debunking the argument that students suffer if you spend resources to provide these courses. And here's a picture of that, right? This is just showing you over here, right? Public-private, we know the difference, but you see the difference between schools that do and do not have enough capacity now is inconsequential, at least statistically. Okay, here we are, right? So I was running this stuff this summer, and I said, holy cow, I'm afraid what's going to happen when I just look at clinics, right? And I really was afraid, and I said, and then I ran it, and it was okay. And so watch this, and I ran it every way I could run it. I'm telling you, if you got another way for me to run it, I'll run it. It's just not there. This is price, not cost now. Let's make clear what we're still talking about, right? So I sort of did the same thing I did before, right? I said, okay, let's look at the ratio of the number of clinical positions in your school to the tuition, right? So again, let's take an example, right? Let's take a school with 100 students, and maybe they have enough slots for 75 students in law clinics, okay? Their ratio would be 0.75. I put all the ratios of all the schools, right? Again, from probably 3 point something down to 0, because some schools offer no clinics. And I have the same thing with their tuition, and then I want to see, is there a relationship to that, right? As schools offer more law clinic slots, do they charge more? And the answer, again, is no, right? Tiny number, wildly insignificant statistically, okay? And so I cannot statistically show any relationship between providing more opportunities for law clinic experiences and tuition. It's not there. Again, I'm not saying clinics don't cost more. I'm just saying the end result of that is not being borne by students in terms of higher tuition, okay? But I want to look at a lot of different things here, right? Because I know this is just hard. I presented this to my faculty. They were just didn't want to believe this. You know what I mean? It was so ingrained in them not to accept this, okay? So I looked at a lot of ways to do this, right? So this first one I just showed you was a straight line, right? I line them all up, and I say, from the schools that has the most law clinic opportunities to the least is their relationship with tuition. Then I just looked at the ones with sufficient capacity, right? So I think there's like 45 schools right now have enough slots in their law clinics to mandate a law clinic experience, not just a clinical, right? And so I said, well, what about those schools, right? Are they charging more, right? Because that's a pretty unique situation, right? Are they charging more than the rest of us, like my school, that doesn't have enough to mandate a law clinic? And again, the answer is no. In fact, my gosh, they're charging less, but that number, again, isn't a number that I'm going to tell you that people charge less on. Yes?
I'll just speak loudly. Can everyone hear me?
It's right behind you. Remind people who you are again.
Linus, again, from DePaul, Minnesota. I actually find this a little counter to what we are looking for, because it seems to me what's going on is that the market for legal education is setting the price. The demand for students to go to law school is they're willing to pay X amount of money based on the ranking, right? If it's a higher ranking, they're willing to pay X thousands of dollars more, and so on. The fact that it's not affected by clinical programs makes it harder to make the argument that schools should adopt it, because it says it's not adding the value for a student to be able to say, I'm going to go to a school that has more clinical education.
You're right.
Because it's the price of the law school tuition is based on supply and demand, but that's not being differentiated between schools with clinical programs and not with clinical programs.
Right. So that's a fair argument, and that's a pricing argument, right? And the price theory, and my law and econ faculty people, of course, point this out, right? So here's the argument, right? So the argument is that one reason schools can't charge more is because students won't pay more, right? And so even if you advertise you have a lot of clinics, you can't charge anymore. The problem with that is, as you know, there's a lot of things going on that both one sets price and two that students see and hear and know, right? So I would agree, right, that if you came to the supermarket and you had school A and school B and they were ranked the same and in the same city and everything was the same, and one charged a little bit more for law clinics than the other, and one had great law clinics and one had none, and people didn't buy the one or pay the extra money, I would completely agree. But like all law and economic theories, the market just isn't that pure. You know what I mean? Students' signals that they get, they don't, hell, we didn't know these numbers, right? Did you know these numbers? I didn't know these numbers. So how do we think a student, right, trying to figure out where to go to law school has all this information, and at the end of the day, because usually they're not choosing between two identical schools but for that, right? And so I understand that argument, but all the non-economic market-based data says students care. The LSAC, when they ask you what's important, the second most important thing behind location for a student's choice of your law school is the availability of clinics or externships. I know when we do our own internal survey, that's the nationwide one, we get it to be the number one reason why they say they choose WashU over another school. So I just think that from a sort of law and econ perspective, you can make that argument, but from all the sort of other empirical data that asks students, why do you do things, they say it does matter. So.
Hi, my name's Doug Colbert from Maryland Law School. So let me just pick up a little bit on what you're saying now, because that's was what I was thinking was, why couldn't schools make it a marketing strategy to advertise the fact that they provide this live clinical education, not just externships, but real live client, and we make that part of our strategy to appeal to the students who really do want to come to law school, not just to have the theory, but to engage in the practice. And so one way of dealing with under-enrollment at so many schools is to say, we are one of the 30 special schools that we care about you graduating, knowing how to practice law, knowing what it means to be a lawyer.
And I think that's what's going on. I think the reason so many schools are adopting mandatory clinic isn't because suddenly the faculty got religion about how good they are. I think they see it as an ability to get one up in the admissions process. I mean,
and there's nothing wrong with
no,
because that will actually
use it.
save
I'm telling you today, go back and use
education
this.
in many ways.
I don't care why they do it. So let me just show you a few other things real quick, and then we can talk about some more, just so you can see I beat this. I shouldn't say beat this horse. That wouldn't sound right. I looked at this as every possible angle to try to sort of prove that this worked. So then I thought, what about the relative ratio of law clinics to externships, right? Maybe what's going on here is are schools that provide proportionally more opportunities for students in law clinics charging more than schools that are heavy on externships, right? This really is a difference in cost here. Again, no, tiny difference. And again, it's at least getting closer to something we might rely on, but the difference here, it just really doesn't show it at all, okay? So then I said about this. Let's try another angle, right? Because I know I got these doubting Thomases. What about the percentage of students that participate? This comes off a CSAIL survey question. We asked, what percentage of the students at your school take a law clinic, right? What percentage of students at your school take an externship? And we thought, okay, what about this, right? If more of your students are taking a law clinic, is it costing students more in tuition? Again, the answer again is no. Tiny number in the wrong direction, really unstable, predictable value in that, right? And so then on my last show, I wanted to look at the issue of ranking, okay? And does quality cost more? This is, and I apologize if this is the only variable I have, right? Do schools that are perceived by their peers in the U.S. News ranking system to have better, in some way, clinical programs, do they have to charge their students more for that, or are they, right? So I looked at the tuition and fees at the schools that were ranked for the ones that are not ranked by U.S. News, both the ones in the hard copy, the top 15, and the bottom. There's pretty wild variation there, but again, these are numbers that you really can't make much of. So I think at least it's fair to say that at least statistically there does not appear to be any difference in what our students are being charged to have a quote-unquote quality, or at least perceived quality, clinical education and not. So what can we conclude from all this, right? So a couple things. Both we can conclude, I think initially, the California requirement should not cost students any more money, right? Let's get that off the table. And even if we were to, adopt a mandatory clinical requirement, it doesn't, right? Because what do we know, right? Students that are provided more experiential opportunities, that would be the first thing we ran with simulations plus clinics plus externships. It's the California requirement. Or clinical education opportunities, that would be law clinics plus externships, or even when we dug down, required or guaranteed a clinical course, are not paying more in tuition. And conversely, right, this is the thing that I think is equally troubling, at schools that aren't giving their students that opportunity, they're not passing it on, right? So from a market perspective, they're paying and they're not getting what they ought to get, right? And so this is the bottom line here. There's no reason why schools can't do this, and at the end of the day, not have this adverse effect that people worry about on students. I got a paper on SSRN on this that's got even more charts for you, Virgil, if you want to look at them.
I read it.
Okay.
And now I understand it.
Well, good. So,
Is this PowerPoint at that website? Where can we get this PowerPoint?
You have it.
you have it.
No, I mean,
Oh,
Well,
electronic.
the website is a better place to go because the website talks about, it's got all the data, in a sense, yes, all of this would be there.
but how about the
And
PowerPoint?
this would be there in the,
How about the PowerPoint using it on some people?
So
I'll come to your
this-
school. I'll come to your school.
And,
Let me
and
say something before I forget. So when I gave a similar presentation of this at the Southern Clinical Conference, a lot of people asked me about their school. I can show you where your school is on this, right? I can show you where your school, so some schools asked me and I said, you know what? The number of clinical slots you're offering per student is, in the top third or the bottom third. The number of this, the number of that. So it would allow you to see, if you're interested, where am I, right? Where am I on the continuum of what I'm offering, either individually clinics or the mix or whatever. So I'm glad to pull that for you because I have it all.
And all of the plenary sessions will be on, we're going to post a video on the conference website shortly.
I think the question is, are you going to post the PowerPoint?
If you are open to that, I think
guess-
we can do that.
Yeah, I'm not worried about that. Whoops.
So this is Deborah Buran from Michigan. And what I love about this presentation is the connection between the two. So maybe we could spend a little time talking about that, because what I'm hearing from you is law schools are not recouping the cost of clinics by passing those costs on through tuition to their students.
I think
Which-
they're reallocating resources, yes.
Which goes to the point that I think, Claudia, you were bringing out to us, which is law schools are now possibly looking for ways, deans are looking for ways, to cut those cost of clinics down, to do them more and more on the cheap, because they feel their tuition is inelastic. They cannot raise tuition costs to reflect clinic opportunities because of some other variables.
Right.
So you put those two things together, and the nice thing is it doesn't cost the students more. The bad thing for those of us who want to be professionals in this world is that I think the fact that the law schools are not raising tuition means that we are going to be the ones who eat that cost.
And the thing to worry about is that these courses will be taught by folks to whom a law school has no long-term commitment and in whom they have no investment and who have no investment in the law school.
So a couple.
I just want to sort of make a little bit of a counter. As one coming from a more purist, we need more full-time tenured clinicians, I've been convinced of the value of adjunct-run clinics. Partly it is market-driven, but carefully crafted collaborations with adjuncts are a good way to expand opportunities. And I just sort of want to make a defense of that, and also, you know, the things that I was sensing as I was moving into this about 3 years ago, and sort of put down on a list for the clinical directors in Puerto Rico, and a nice piece of sort of how do you make this work in a quality way. And it happens on the doctrinal side too, is that adjuncts are used across the curriculum. And the flip side of that is there is going to be a repurposing of doctrinal faculty. And there are pros and cons to that too, but it's a reallocation of the same resources that's going on. And we're experimenting with all of those things now.
Yeah, so think about a couple
I want to agree with you, Virgil. I think people who practice law in our communities are an extraordinarily valuable resource. I would not be as good a lawyer as I am today if I had spent the last 20 years all by myself in a clinic with law students. We need partnerships with lawyers because they're lawyers. But the worrying thing is that there will not be enough of us left to partner with them.
But think about a couple things. Let's just take your argument. One is, and I show this in the article, there are some huge costs in law school that so dwarf us that need to be discussed, right? I mean, that's the key. In my view, I tell my faculty, I'm more than happy to talk about what my courses cost, but when 40 or 50% of a faculty member's time is spent on scholarships, when we're building these huge mansions to put our, I mean, it's just a lot of stuff that needs to be on the table, okay? But think about what you also just saw. At 80% of the school, you don't need that argument, right? We're not adding anybody, right? Now, maybe there's an argument about cutting, but at 80% of schools today, you can do it, and you don't have to think about, oh, do we have to expand our externships or, bring in cheap simulations or whatever. You are there already. It's just a matter of whether the school believes that ought to be required for a student or whether it's simply a student choice.
David Moss from Wayne State. We're one of the schools that recently adopted the requirement. We have 6 credits of professional skills and 3 credits of clinics or externships. But part of the way we did that was we looked at what we were already offering, and we saw that, gee, we could do this without adding anything. Why shouldn't we? I thought there was an interesting juxtaposition between the 2 presentations. Claudia, you talked about the New York Bar or the New York Court of Appeals imposing a pro bono requirement, and all of us across the country, by virtue of one state adopting such a requirement, now need to think about what we need to do to our curriculum in order to make sure that our students will be eligible to practice in New York. Bob, you talked about a potential requirement in California, the biggest state, that would require 15 credits of clinical or professional skills education. I can tell you, having very recently looked at what we're offering at Wayne, that we're able to do 6 without any additional cost or without substantial restructuring, but 15 would be an enormous stretch. It would mean repurposing a significant number of doctrinal faculty into teaching skills. Maybe that's a good thing.
I don't know if that's true. Let me just say why. So our school, so it's very hard I would love to be able to find out how many slots, how many total slots. I'd love to be able to figure out where schools are on the continuum of 15 per student. I can't because I know the number of slots, but I don't know the number of credits behind the slots. You know what I mean? But I did it for my school, okay? And it turned out we have way more than 15, okay? Because we have lots of simulation courses at night taught by adjuncts. You're in Detroit, man. You can do it. You don't have to reposition doctrinal faculty. I think you probably would just have to do, again, what Washington and Lee did. How can you think creatively, right? Not for your clinical course, right? But for those simulated courses, how can you think creatively about using these adjuncts to come teach some really interesting, more narrow, drafting skills courses? One more question. Gosh, I'm not choosing that one. Well, 2, come on. We can live with 2. Go ahead.
First of all, I want to thank Bob. it's been, I've been.
Who are you?
I'm sorry, I'm Kate Cruz. I'm at Hamlin University School of Law. I've been the president of CLIA this past year, and Bob has been absolutely, he dropped my name saying, you know, oh, Kate Cruz's leadership in this CLIA 15 credit petition. Bob has done that. Bob has done this. Bob has done so much for our community in terms of gathering this information and pushing it. I want to go back to Claudia's first point, which is I'm really concerned that the protections that have been in the ABA standards for security of position for clinicians are gone. And I don't hear anyone doing much of anything about it. CLIA files statements about it, but there's not really a groundswell of opposition. It's a really hard time to develop a groundswell of opposition to that because if you read the blog posts, they go, oh, boo-hoo, poor law professors, ha-ha. You know, like, it's sort of like, there's not a lot of sympathy for us. There's not a lot of sympathy for tenure. There's not a lot of sympathy for security of position. But I am really concerned about the inequality that's going to result in schools as a result of taking away this, this push that this floor that the ABA has set for clinical professors and allowing the floor to drop out without changing I'm really concerned about it. I really encourage people to think about ways that we're in a notice and comment period. It is not hard to send a comment. If you look at the ABA Council website, comments that they are posting look like they've been cut and pasted from emails. They need to hear a lot of comments. They need to hear a lot of comments about people's concerns about this. And it's not hard for people to make individual comments. I really encourage people to do that.
We're going to have an affinity group tomorrow morning at 8 a.m. if you want to come join us.
Yes, strategic thinking tomorrow morning, 8
brainstorm
o'clock.
about this. Thank you much. Go forth to your school, huh?
And there is an eval form coming around. I know it's long, so pick one question to answer on the form, and there'll be feedback for Bob and Claudia.
No, I
I
can,
think
but
there is
that requires
coffee in
my
the law
poor
school atrium.
assistant to pull.
I
can't.
The concurrent sessions start in 10 minutes over in the law school. So you either can walk outside to the law school or go up into the Skyway.